All rise.
Please have a seat. This is matter number C 2007-2073, Democratic Party versus Pima County Board of Supervisors. This is the time and the place for hearing on plaintiff's motion to amend findings of fact or law, or alternatively for a new trial. If counsel could please announce. Start with plaintiff.
Yes, Judge Bill Reisner for the plaintiff, Pima County Democratic Party, and sitting at council table as a representative of the party is our Vice Chair, Moher Sidwood.
Yes, Your Honor. Christopher Straub, Deputy County Attorney on behalf of the Board of Supervisors. With me also will be presenting today potentially is Mr. Thomas A. Denker, also Deputy County Attorney. Sitting at our table also, the record should reflect our Director of the Office of Strategic Technology Planning, that's Dr. John Moffett, who's also present as our client representative.
Counsel, before I hear the substance of your arguments, let me address what I think are several different sets of motions that are pending. That takes care of that. And then I just received some papers asking for oral argument on another motion. I may not have brought them out with me. It wasn't entirely clear to me that it pertained to this case or it actually pertained to the other case. Can someone tell me about that?
No.
Sure, Judge. Is this the motion and request for hearing on disclosure of all election data files?
Yes, sir.
You know, at the really the last paragraph of your ruling, you said it's further ordered denying plaintiff's letter request for every file, but that denial, it said such denial is without prejudice to plaintiff to re-urge the request after it has had the opportunity to study the MDB files for the 2006 elections and address the current and any future security concerns raised by Pima County arising from the disclosure of many MDB and GBF files. So Your Honor contemplated that the data files prior to the general and the primary in 2006, that once we looked at those, we could come back and ask for a hearing and say, and show that there's no security risk on the release of all of those files. So what I've done in this motion, I attached two declarations. One's from a Dr. Thomas P. Ryan, or a guy we call the second Tom Ryan, who is is actually a lawyer, but he's a computer scientist. And you may recall there was an exhibit, I think it's Exhibit 17, but there was an exhibit in this case, a trial of a peer-reviewed article that related to the defects in the GEMS and the use of the Microsoft Access JET database and so forth. He was one of the authors of that and was the chief computer scientist in the Cuyahoga County collaborative audit that was conducted after the 2004 election. A copy of that was previously filed in this case at the time of the motion for stay. So I attached a declaration from him that said that there's no security risk. I've attached a declaration from David Jefferson, who is a scientist, a computer scientist at the Livermore Atomic Laboratory in California.
Well, Mr. Reisner, before we get into the substance of what you're requesting, I'll give you that time. I was trying to understand how it related to today's motion, and I also needed to know, probably for both of these, whether there have been any additional agreements between the parties as to the release of computer information or any other kind of information after my order was issued. Well, let me hear from Mr. Reisner, and then I'll hear from you, Mr. Straub.
Well, your last order, I guess, in order was to, in chronological order, was for the clerk of the court to provide the data that was in the court's vault. And that data was taken to the Board of Supervisors hearing room, where the Democratic Party, and actually copies for other political parties, downloaded the RTA information and all of the iterations of the RTA and the 2006 primary and general election. So your ruling had used the term final database, and one of the issues that I had raised was not quite clear to me what that meant. But in any event, it's my understanding that we now have, as well as the other political parties, the complete set of all the data from the RTA election and from the 2006 primary and the 2006 general election. But getting back to your specific question, the request for the hearing to give us all of the data is intertwined and overlaps somewhat with the motion to amend the findings of fact and conclusions of law, in that I'm arguing in the motion to amend the findings of fact and conclusions of law that there was not sufficient evidence presented at trial to back up the ruling where you found that there was some risk on giving us all of that information. This motion deals with it from a different direction of saying, okay, even if you were to conclude and not change your ruling, even if you concluded that there had been sufficient evidence that there was some risk, you nonetheless said in your ruling that we could come in and show that there in fact is no risk now that we looked at it and have more information. So really, both of them deal with somewhat the same subject matter. And if you were to agree with us that there was an error in your original findings of fact and conclusions of law, then I take it that moots the request for a separate hearing dealing with whether, now that we've looked at it, there's any risk.
Let me make sure I understand something. Do you believe that you received, pursuant to the agreement that you entered into, in that stipulated order that I signed, records that I didn't specifically authorize to be disclosed immediately?
Yes, no question about it.
Are there also still records that have not been released?
Yes, but it's the pre-May 2006. So it would be 2005, 2004, going back, I think, to 1997. There may be some 96 stuff, I don't know. But it's prior, it's 2005 and back. We have all, at least we have those 3 elections from 2006.
You have received now all of the copies of all databases for 2006. Is that correct?
No, well, I don't know about that, because there may have been, a school district election or something else. We've received the Regional Transportation Authority data. We received the general election and the primary election 2006 data. But like I said, there could be Marana, Sarita, there could be other stuff that wasn't in what we received.
So basically, you've received all of the databases or their iterations for primary, special, and general in 2006?
Yes.
Strawberry.
Yeah, Judge, with respect to the new motion, we've never concerned with that motion. We discovered it by taking a look at the court's website as we check periodically, so for whatever reason, it may have been a problem with our fax machine or whatever, but in any event, we've not seen that motion until just recently. Second, the motion essentially is another bite at the apple. I don't think it has any place with respect to the motions that are before the court today. The judge, your order of December the 18th made it clear that their right to be able to come back to you to ask for these additional databases that have not been disclosed was clearly dependent upon what they discovered and what they got as a result of the court order.
Mr. Ross, can you tell me what exactly has been given to the plaintiff? Because when you all came in, that, as I recall, was late Friday afternoon.
Yeah.
You simply gave me an order, and as long as you all agreed, I was willing to sign the order. I read it through, it seemed reasonable, but what wasn't apparent to me was whatever happened between the time my order was issued and when the agreement was entered into, such that more records were released. I had anticipated a process of an initial set of records being released. To the extent that there was going to be continuing security concerns, I would have expected that someone would tell me about them, and if there wasn't any, then, as Mr. Reisner indicated, the plaintiff was authorized to come back into court and say, give us the rest. Right. So it sounded like something happened.
No, I don't think...
I'm reading in papers that there were, given to me, that there was a Board of Supervisors meeting.
Yes, there was.
And was there a decision to release additional records than specifically authorized in my December order?
Yes, Judge. Let me go through the chronology. The court ordered only 2 files out of 1,156 files to be released. Those were the final databases for the November 2006 election and for the September 2006 primary election. At the meeting of the Board of Supervisors, the board, at that meeting, there was a question as to whether the board was going to appeal Your Honor's decision with respect to that or not. The board chose at that meeting to release 3 things, actually, is what it did. It agreed to release to the Democratic Party the 2 files that the court had ordered and released. In addition to that, what is reflected in the order that you also signed as well, too, are the records for the RTA election as well. Also, within that, with respect to those 3 elections, it wasn't just the final databases that was released, but it was all the databases. You'll recall Brian Crane's testimony, and that would be part of my presentation later today, that a series of databases is created, or database files is created during the course of an election. And it was that entire series, just for those 3 elections, that was released.
Do you have an idea of approximately how many separate files those 3 elections and all their iterations comprised?
Yeah, it took a while to download that, but it's around approximately 300 files. So remaining would be about 800 more files with respect to that.
And how do you categorize those remaining 800 files, both by time period and by election?
Well, they include a lot of different types of elections, Judge. I mean, they will be for example, the primary and general 2004, the big elections, okay, the 2000, the 2002 generals and primaries, those really big elections with lots of database files. Then there's everything else in between. There are Oral Valley elections, there's various school board elections that we do, as you know, the division elections. Occasionally we'll operate under an intergovernmental agreement to conduct the elections for various jurisdictions. So we have City of Tucson, we have different, City has its own method, but we need City of Oral Valley and some of the other smaller towns, fire districts, those kinds of things. There's everything in there, including elections from Boys State and Girls State. They do that for the high school students as well. So the databases with respect to things that we would deem inconsequential to everything that to some of the bigger elections.
Well, let me get an idea of first what the time frame is, then we'll talk about the category. Do you agree with Ms. Reisner that the county is in possession of MDB files from 97 through 2005?
I would have to check with Dr. Moffat with that, but I think our respective year review said.
I don't remember saying 97, but I can go back and check. But it's 98 forward, I do recall seeing that.
Yeah, there's fewer number as you go back in years, as I recall. In other words, there may be, a general election for the year 2000, or excuse me, 1998, but it won't be nearly the extensive number of files that we have, say, for 2004.
How did you
2005.
come to the conclusion that there were approximately 1,400 files at issue?
That was through Dr. Moffat's work with respect to this.
Okay. Well, I don't want to turn this into an evidentiary hearing just yet, so I'm going to have to rely on you, Mr. Straub, although I don't mind if you consult with Dr. Moffat.
Yeah, you may feel free to ask him directly about that, which I'm not able to answer, Judge.
No, again, since Dr. Moffat is not an attorney, I want to be very careful here and not raise questions as to whether I'm hearing testimony or I'm hearing the position of county. Mr. Reisner, with that understanding, this isn't testimony. Do you mind if I ask Dr. Moffat questions?
No, that's fine.
Okay. Dr. Moffat, how was it estimated that there were 1,400 files?
I essentially took, when the copies were sequestered for the court, another copy was made for our files, and I went through and analyzed that set of files, just did a count on all the files that were on the directory, both MDB and GBF files, and that's the total, which Mr. Straub indicated included, non-county elections. It was all the MDB. The process was giving all the MDB and all the GBF files. That was the total.
Can I assume from the testimony that I heard that for every MDB file, there's also a GBF?
No. There will be, in some cases, there will be more GBFs because they make backups as they go, and there's only one operating MDB file. In other cases, for each election, as we get further back, they would only keep one MDB and one GBF, so they would not have as many files.
So I think I better hear anything else you have to say about amending my order or granting them a trial. Is there anything else you wanted to add?
Sure.
Go ahead.
Yeah.
And Counsel, by the way, you asked for 30 minutes. I can give you an additional 15 minutes, but I do have another hearing that begins at 3:45. So, Mr. Reisner, I'll ask you to be relatively brief and concentrate on whatever you think needs to be clarified or something that you haven't put in your moving papers.
Okay. Judge, I'd like to just focus on first this terminology of final database. And if I understood the court correctly, the way we took it, the court was in error. And at the supervisors meetings, one of the reasons that they gave us the complete sets for at least 04 and 06 was that they agreed with Mr. March, and Dr. Moffat also agreed that there was no possible security risk in getting the complete set for one election. So I mention that because in a case where the county has the burden of proof to show that there's some security risk involved, when you have the election set up, then it's frozen. There are things that shouldn't change. And so all the way through, there's no possible risk from beginning to end in knowing what the setup is at the end and what the setup was at first. But all of those iterations in between are extremely important in the history to see if in fact there are any changes, to see in fact what happens. Some things shouldn't change, and if those things that shouldn't change, then that's what we need to look at, and that's what we need to know. And of course, none of that information is available until after the polls close and the election ends. So it's extremely critical to get the complete set. And I would suggest if you look at the RTA, one of the interesting critical things about it was the original setup. That's the tape that disappeared because it is of high evidentiary value in examining at the end. So in any event, when the court...
Excuse me. One of the reasons I was so focused on what had happened since my order is because this is a pretty unusual situation where essentially what you're doing is you're saying that the government authority made decisions and made statements, I suppose, in a different hearing after the trial on the merit that I should then consider in a motion for a new trial. It's almost as if in the context of civil litigation between the parties, one of the parties did something. After the trial was all done, after the jury had rendered its verdict, and you come back into court and you say these are essentially newly discovered facts. Because I think what you would want me to do is take Mr. Moffat's statements, I think it was Mr. Moffat that you quoted from in your papers, and use that in order to modify my trial findings.
See, I'm not trying to do that. I really was just trying to do that as an example as to how somehow you were led into making a grievous error. Because there is no possible security risk. It's just wrong to conclude that the evidence showed there was a security risk. And my argument is, no, there was no evidence as to that. Just like there was insufficient evidence as to there being a risk for us getting information from 1998 to 2006. There's no evidence for that. And I understand that the court may be somewhat befuddled by saying, gee, if the county is fighting so hard, there must be some reason. There must be some risk. But I put in my motion, and I went back and I listened to the testimony of Dr. Moffat, the testimony from Merle King, and I listened to the arguments from Mr. Dinker. And this case is, well, let me arrive at it by looking at some agreed upon facts. It's undisputed facts in this case that the Democratic Party has been helpful in increasing security at the county. We've got in evidence, and there's plenty of it, about all of the changes to the physical security, changes to the procedural security, reports from Dr. Ryan starting in 2003 about problems with computer stuff, Mickey Donahoe's work, all of the efforts. There's no question that the Pima County Democratic Party has spent years in improving security. There's no question, and it was stipulated, that Pima County uses a system that is easy to cheat and easy to cover its tracks. Now, we need and can use, and it's useful in getting this data as part, and the court agreed that the Democratic Party has a statutory right and a critical role in our system to track and to see what's going on with elections. The defense in this case was an outrage. The defense in this case was that the most serious risk, according to Mr. Dinker, was mayhem and chaos. He says there's people out there that have an interest in discrediting the system, that have an interest in discrediting the administration, an interest in discrediting the electoral system, discrediting potential vendors. He says, quote, if they get the MDB file, they will have all the parts they need to discredit our system. This is a serious risk, and that is what is at stake. That's a quote from the arguments there. What was the testimony from Dr. Moffitt? I went into that in our motion. He said the number one risk, this was what the county is worried about, the number one risk is that the Democratic Party could get a copy of the election results from these guys, and then because we knew how the pages were lined out and the reports were made, make another report that was different to sow discord, to sow doubt in the election. Let's step back a minute. You know, there's when you look at attorneys' fees and other issues, in civil cases, there's an obligation to come in with real defenses. There's an obligation to come up with real stuff that has meat that hangs on it. There's a reason to go to court. And the testimony for Merle King and all these people, it's imaginary stuff. That there's people out there. There are people that want to sow discord. But the Democratic Party and every political party in this state, it's not just us, we all have histories from prior to statehood. These parties were here and they've worked, and hundreds of people and thousands of people, and we're part of the system. Can anybody say, or is there any evidence here that would put us or anyone else that we're part of something that is discrediting the system? That was the defense in this case. The number one. Dr. Moffitt, you got number one or two? Number one is you can print those things. Number two, there's this stuff with, you could make your own ballots, all of those kinds of stuff. It's absolutely the case that there is no risk. There is no risk other than it helps us develop a system of seeing what's normal, what's usual, because we are engaged in that process now of developing a computer program that will assist. And this is important because, you know, Your Honor, in arriving at this decision, had to balance. You had to balance the public interest. The public interest of a political party that's part of the system, that has been trying to improve the system, that has worked for decades and decades, and isn't trying to destroy an electoral system. You have to balance what can we use to legitimately go ahead and perform our function against what does the county have on the other side. And what they had on the other side is there's people out there that could do something, and there's people that want to engage in the system, and maybe a political party would present and print fake reports. And you clearly pointed out in your order, heck, that would even be a crime. It's only stupid, it would be an absolute crime. So my motion clearly says there was no evidence on which you could legitimately find that there was a security risk if the Democratic Party got the pre-2006 election return.
Judge, our basis, without going into the issues, the other issues he's never addressed either in his replies or otherwise with respect to findings of fact 2, 3, and 5. Not going into 19 and 20, since I think that's, at least with respect to the databases at issue here, is now moved by the county's disclosure of that information. That leaves us with findings 29, 31, 32, 33, second iteration 33. and we believe is a tax, and these are totally without merit. As the court is quite aware, the county basically had two concerns, essentially. One, that the ability to provide this information unchecked to the public. And this court made this finding, is it's not about the Democratic Party, because this court made a specific finding which is not challenged, is that this stuff is going to go into the public domain. And we're not talking about whether political parties would do anything to discredit an election. It could be anybody or any group of people, or it could be political parties acting in concert, depending on when this information is released. This argument is important because the question is how we behave going forward. Second, there's a potential, not only an attempt to discredit elections, but that there is both known and unknown security threats. That's what this court found. And that was all based on testimony of witnesses. The court got it right with respect to finding that the government has an interest in not just willy-nilly disclosing everything. I want to just touch base in the few seconds that I have here, being mindful of the clock, about this issue of discrediting. He's saying that the Democratic Party would never, ever discredit an election or attempt to use any data that has been received or whatever to do that. And I give you as Exhibit A, the RTA election, because that's exactly what's been happening for the past 8 months in this courtroom and outside this courtroom. And numerous times that he's been in front of the press talking about the RTA election and talking about and making slanderous accusations about our election employees. What he has done here in this case is shameful. And this court should understand that and use that as a justifiable basis as to why you do not disclose sensitive electronic information. The plaintiffs were simply because the county was trying to give them as much as they could, gave them access to simple audit logs to show, the process of the elections as we go forward through them. And from that audit log, we had the testimony, of course, of Brian Crane, and that was not disputed by Mr. Reisner, as he simply made a keystroke error and overwrote a file. Department. Now, why do I get exercised about this? The reason I do is because this is what happens when you discredit an election. This is the RTA. The RTA has bonding authority. Decisions, when you discredit an election, like, for example, at the RTA, then the question is, if the RTA were to ever go out, and I don't know whether they're going to bond or not for indebtedness, but there's always going to be this black mark, and that's going to affect the credit rating of the RTA. It's going to affect what the interest is paid on those bonds. This is not a trivial matter. And it is, I know that we're all interested in election integrity and transparency and that sort of thing. All very well and good, but not at the expense of the security of elections, not at the expense of the integrity and the faith that people have in their electoral system. This is frankly outrageous, and it's time for this court to put a stop to it. And it can do so by denying this motion. It's interesting. I want to tell you what the effects of this are. The board, it was, I don't know if you saw the board's meeting or not with respect to this. It was a somewhat chaotic affair, to put it politely. But here's the dilemma that the board is faced with. The dilemma is it could either just agree to turn over the limited files that you ordered and that you thought in your discretion would not impair the integrity of other elections going forward. Or it had to make the choice with respect to, there's all these allegations with respect to the RTA. He's on the John C. Scott show right before the trial of this matter, talking about how terrible the Elections Division is. And then we have this article by Gary Duffy in The Citizen about the infamous, copy of the tape and all this stuff that creates this doubt. The board is down in a position that has a real legitimate concern about the integrity of elections going forward. It has to weigh that now upon the idea of wait a minute, we got to clear up the doubt about this past election. And I think the board could reasonably conclude, okay, we might as well just give them, the RTA stuff. That should put this matter to bed. This matter should be all done with. There should be no need for these folks to come back in here and take your time to say, well, we want yet more files. But instead, no, it just keeps going forward. And,
Mr. Stroud, could you address the same question that I posed for Mr. Reisner? obviously, things are happening outside of my courtroom. You refer to it in your papers, but I can only make my decisions based on the testimony that I hear here. I can't make a decision based on what may occur. In fact, both parties may agree that something has occurred, although I suspect you don't always agree on what occurred or why it occurred. Do I take into account, and can I procedurally take into account actions, for instance, that the board took after I issued my order at the end of the trial?
No. Judge, I think what the problem is that there are always consequences to this decision as to whether or not to disclose sensitive election information. And Mr. Reisner, I think you had asked him earlier on when we were presenting the stipulation to you on that Friday after the board's decision to effectuate this transfer of information. You had specifically asked Mr. Reisner to update you and file a pleading with the court. And we've not seen anything. Perhaps the same thing happened in the February 13th pleading. It was not served. And I think, though, that it is important, and certainly for purposes of a new trial, he's not presented to you anything here that would suggest that your ruling should not stand. And in fact, the testimony of this court in its findings, in fact, particularly finding 31, quotes Mr. Donahoe, his own witness, saying that from a security perspective, this is not a good idea to release this information. As to your specific question, again, as to whether you consider materials outside, I think that's up to the court to decide whether it wants to in terms of the policy reasons as to whether or not it should grant a new trial or whether or not it should allow the release of more and additional information. And, Judge, it's just that this court's decision was well thought out. I mean, I think obviously we believe there was still an aspect of error in the release, even those final databases, because they contained the critical setup information, which Mr. Reiser now all of a sudden is willing to concede that's really the only important stuff here, and indeed, that's the very same stuff that's sent to the Secretary of State. But be that as it may, we're at this point now, and we have to deal with elections going forward. And what I would ask the court to really seriously consider doing is to say, well, wait a minute, due to the potential for discrediting of information, at least uphold your finding 29, at least uphold those findings where you clearly state in there, hey, it's not a good idea to give this stuff away on election night, or maybe even a few days or even a few weeks after the election.
Let me ask you about that point. You're taking this to a different area that I don't believe I addressed or heard testimony about in the trial, and that is a declaratory judgment with respect to future databases. My order was basically focused on the databases that have already been created. That was the testimony that I heard. I really only heard indirectly any issues about future elections, and therefore my order didn't address them. Now, you're raising it in two contexts. You're raising it in the context of whatever I do is effectively going to act as a declaratory judgment of the future, or if that's not what you intended, you're at least raising it as if I either affirm my prior order, it's at least going to have an impact on future elections. And I'm not sure I can really consider that either, since I didn't hear any testimony about what is the relationship between my order about elections in 2006 and whatever the county may decide to do about elections in 2008 or at any other time.
Judge, I'm reading your sentence here, the last sentence of 29, because I think you essentially say that what you're trying to deal is with certainly past aspects about it, but it says, but this sentence here, I think, does give at least the county some hope going forward. Now, it might have some res judicata effect, and that's why I've spent the time taking with respect to that, and that is, release of the MDD files days or even weeks after the election significantly reduces the concern that valid election results could be challenged with an altered MPD file. And it was that sentence that we thought looked prospectively. And to the extent that Mr. Reisner has already alleged that he's got this amended complaint where he's alleging declaratory relief going forward, I thought reading that language prospectively made sense in the context of what the complaint of in the complaint by Mr. Reisner.
Well, certainly the plaintiff has taken the position that to the extent that I understood that there was no request for election results until at least several weeks after the election, my understanding of the testimony was mistaken. I think that's the plaintiff's position now.
Well, that's what
Motion for
he's
a new
alleging,
trial.
and I'm saying it's not.
Okay, and I understand there's a conflict in either the testimony and or the arguments. I have to wrap this up pretty soon because I don't want to keep the other people waiting. What is your position, though, on what you've heard in a preliminary fashion about the release of all of the other databases from 97 or thereabouts until 2005? Because as I hear argument of counsel, I'm increasingly concerned that these two matters overlap and that I probably can't issue a decision on the motion for a new trial until I hear full arguments on the request for other databases, because those two are pretty, they're linked, if not actually interrelated.
Well, that motion is essentially, the new motion is essentially a second bite at the apple. We have
You
not.
don't have to argue the merits.
Yeah, we don't need.
I want to know whether I should hear it before I issue my decision on the motion for
I
a
don't
trial.
think you have to do that. In fact, I think that the evidence that you have before you already is already presented at trial sufficient in this regard. Judge, I don't think I answered your question. Could you?
No, I think you did. You said that you don't think I need to consider the motion for the trial until...
If your question raised something else, I just forgot.
That's okay. Let me ask Mr. Reisner the same question. Mr. Reisner, I just told Mr. Schraub, I really am concerned now that I ought to hear the full arguments and that I should deal with both of those because for understandable reasons, the parties are doing things outside of court to try and resolve your differences, which I encourage. Where the problem arises is that you don't fully resolve your differences. And as long as you don't fully resolve it, then I'm left with having to take into account whatever it is that you do resolve, but still issue rulings on the matters that aren't resolved. Do you agree with Mr. Straub that I can decide all of these independently of one another? Or are they really related and I should hear all of the arguments?
Well, first, my first position is that there was not sufficient evidence and that you should amend your findings of fact and conclusions of law based on the testimony that was heard. The motion for a new trial, and this is an unusual perspective for me because I generally don't have court trials. But the rule on motion for a new trial is not for a whole new trial, but is strictly on the issue of is there a risk of, at the time, giving us the complete iteration, which is now currently not an issue in the case since they agree. So it's only on do we get all the old data? Because the new trial rule says when it's a trial to the court, if there's a specific point that it would be useful to get additional evidence on, then you can ask for additional evidence on that issue only. And that issue only is the same issue as the motion to get all of the past data. So both the motion for a new trial and that pending motion based on your ruling go to the same point.
What about what Mr. Straub just raised about essentially asking for declaratory relief with respect to future elections?
Well, I clearly am asking for that, and I believe that there was testimony from that. And as I pointed out in the pleadings, it's absolutely important because of Arizona law that says you've got 5 days to challenge an election and you must plead specificity, which is why we did offer testimony saying that there's no risk once the election's over, the polls are closed, The only question we had was, you know, we don't need it at 8 o'clock, but why can't you give us data later that night or the next day or something? You know, or maybe there's an argument that, yeah, you don't get it until we're ready to have the supervisors canvass the election. But once the polls close, the elections are over, all the ballots are in, there's no harm in giving us data where we can start to look at it, or anyone else. But we absolutely must have it in sufficient time to be able to look and analyze it as would the candidates or anyone, so that anyone who wants to challenge that, they've only got 5 days, and they have to have a verified complaint with specifics. And so saying that you get it weeks later is just means that no one can challenge an election. It absolutely must be turned over, and there only are those fine points. At midnight before they go home, do they make a copy of what they have? Do they come back later? Is there some other date? But man, it's got to be, I mean, the latest would be the canvass, because the canvass starts 5 days, and that's a critical short time span. And sure, we need it, because no one in the world should go through this kind of stuff twice. It'd be good to get these things resolved now.
When is the next election where there's going to come an issue?
Primary, I suppose, is the only one I'm thinking of. It's September.
March or ballot.
Does the plaintiff believe that the March Oro Valley election is an issue here? I can understand why you'd be interested in the primary, but do you agree that, or do you believe that the March election requires a decision? Because I assume that that's the first Tuesday in March. Is that election set for March 4th? Mr. Straub?
Well, we think that's a pretty good guess, Your Honor, with respect to that.
I expect that election's of interest to somebody.
Counsel, I'm sure you're going to appreciate this. Neither one of you completely agreed with my decision, and neither one of you believes that I need to hear both of them together. But after considering all of this, I want to hear the argument on the other motion. On the other hand, I want my decision to be timely. The only way I could have a decision prior to March 4th is to absolutely accelerate your briefing and basically have you back in here on Thursday or Friday.
I can't possibly do that.
Mr. Reisner, essentially you understand that if I can't get you in here that quickly, then I can't issue a decision prior to the March 4th, 08 Oro Valley election.
Yeah, right.
Mr. Reisner, do you have any problem with not accelerating the schedule that much since Mr. Reisner can't participate either?
Yeah, I'm quite fine with that. I did want to raise just...
Well, I'm going to give you another opportunity. I'm going to set a hearing for a more reasonable period of time. Okay. I've already given you an hour, and I've gone into somebody else's time, and I'm going to have to apologize to them for doing that. Let me set a hearing right now to give you an adequate amount of time.
Judge, we may very well also with that response file a motion to strike that motion as well. It was timely and appropriate.
I'm going to put a pretty strict deadline on that motion to strike. I'd rather, I'll deal with it, but I want to get to the merits if I don't find that there's merit in the motion to strike. Counsel, I'm having trouble accommodating both your schedules without pushing it back to the 21st. I can also do that at 9:30.
That'll work for me.
April 21st?
Yes, sir.
That'll work.
This matter will be set. All All pending matters will be set for hearing on April 21st, 2008, beginning at 9:30 for 2 hours.
Does that include the attorney's fees? I mean, I'm probably going to file something anyway requesting a hearing.
I'll have to look at all the papers that I get from all of you by March the 17th, and I'll still have enough time to decide whether I can both hear oral argument and conduct any necessary evidentiary hearings. So you'll have an answer to that question as soon as I see your papers, and I'll make sure that I take that into account. Now, counsel, for these new motions that you filed and you've requested a hearing on, is the briefing schedule such that you're going to be finished with an opposition and a reply prior to April 21st? In other words, I don't want to run into a problem where someone runs out of time prior to the 21st. That should give you more than enough time.
If we just have a little bit of extra time because we get formally served, probably respond.
Counsel, I'll ask the two of you to work it out, and I'm more than happy to sign a stipulation as to your briefing schedule. My only requirement is that you make sure that you get your briefing completed by April 14th. Give me a week to fully consider your papers so that I can read them all and go back to the record if I need to do that. So we'll include the minute entry that counsel can work between themselves as to the briefing schedule, or the court will require that the briefing be concluded no later than April 14, 2008. Okay, counsel, is there anything else that I can or should address? This hearing is concluded. The counsel may be excused.